Joining us now is the Attorney General of South Carolina, Alan Wilson. Great to see you, Alan. Alan, what is your take legally on the prohibition of the castration of children, this case that is currently being heard in front of the U.S. Supreme Court?
Well, first, Charlie, thank you for having me on your show. It was great to see you a few weeks ago down at Mar-a-Lago, and we appreciate all the work that you're doing. First off, I'm involved in this because I'm one of 25 states that has passed a law similar to that of Tennessee. So what happens in the Supreme Court on this decision impacts South Carolina. As you know, Charlie, states have a general police power. Inherent in that police power is the ability to regulate various professions, in this case, the medical profession. We have police powers to pass laws that protect generally the welfare and health care of children. States have passed laws that restrict when a child can purchase alcohol or purchase tobacco. States have passed laws on the ages that children can sit in the front seat of a car, or children buy pornographic materials. I mean, there's all kinds of restrictions that are placed on children that the states have deemed are important for society of that state. And in this particular case, the various states, 25 states in this case, including Tennessee, have passed laws that put restrictions on basically what you called, and I agree with you, gender mutilation and chemical castration of children as minors. We basically determined that it is not a good thing for children as young as 6, 10, 12 years old to make life decisions that they may come to regret, where they chemically castrate or mutilate their genitalia. And so we passed these laws. There are obviously the plaintiffs have sued to basically ask the Supreme Court to raise the level of scrutiny so high that states would not be able to pass these types of laws because they allege that it violates the Equal Protection Clause of the 14th Amendment, which we vehemently disagree with. But again, if states can pass a law that would restrict what age a child can buy cigarettes or alcohol, but we can't restrict when a child can perform an irreversible surgery or a procedure, then the states have had their police powers completely gutted because of a radical leftist woke agenda.
Yeah, and so let's just strongman or steelman the other side. So if I had somebody on this show or that is arguing against you, what is their argument? I can't even think of it. Well, it's very difficult. And as a lawyer, you have to have both sides. So what is the case? I mean, do your best, please, to tell the audience what you are arguing against.
Okay, well, I feel like I need to go into character here. So what they're
as a lawyer, you got to do that, though. So
you do. You have to play devil's advocate and argue against yourself at times. What they would say, and what they argued today in the Supreme Court, and what they argued in their briefings is that you're treating the sexes differently. In this particular case, they would say if a boy who wants to transition, a biological boy wants to transition to being a girl, and that boy wants to take estrogen to help them become a girl, and then there's another there's another girl who wants to take estrogen, you would prohibit the boy from getting estrogen, but you wouldn't prohibit the girl from getting estrogen if she wanted estrogen because she were not feminine enough, and vice versa. If there was a girl who wanted to take testosterone because she wanted the transition, you'd be treating her differently than a boy who wanted to take testosterone because maybe he was going into but he was lagging in puberty, or because his voice wasn't deep enough. So basically, they're saying you're treating people differently based on their sex. But the argument that the Solicitor General of Tennessee made, I thought was excellent. I mean, he was basically saying we use morphine to limit people's pain. We also use morphine for assisted suicide. Giving a drug to someone in the context of that drug, it could have a negative impact on them. Giving a boy who wants to work, has an issue with, for instance, he's developing breast or something, and he doesn't want to have that, giving him a testosterone for the medical purpose of helping him, not have breast is one thing. Giving it to a girl that could have irreversible harmful effects to her in the long term is a completely different thing. It'd be like giving morphine in assisted suicide cases. So that's the equal protection argument that they are making, that you're treating the sexes differently. Frankly, in my opinion, you're treating the sexes the same. You're basically prohibiting both sexes from potentially engaging in harmful behaviors or harmful surgeries that they can certainly elect to do when they turn 18 years of age, but you're prohibiting both sexes from engaging those type of behaviors. Another thing, Charlie, I think is important is that the sciences the science of gender transition are all over the map. There is an active debate. I mean, you have Norway, Sweden, the UK, Chile. You have all these countries. You have 25 states that have restricted this because the science says one thing. You have other countries and other states who argue that it helps prevent suicidal ideation in teenagers. The problem is suicidal ideation, if you do longitudinal studies, goes on for years and possibly decades after the transition surgeries. We just don't have enough information to say that these gender affirming care that they're receiving are actually going to do what people purport that they will do.
So let's play a piece of tape here. This is Ketanji Brown Jackson. Banning trans surgeries for minors is like banning interracial marriage, ? Play cut 88.
You know, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
I mean, this is an outrageous argument, in my opinion, from a Supreme Court justice. I know you have to be careful because you have cases in front of the Supreme Court, so answer it how you wish. But what do you have to say to the categorization that this is even in the same ballgame of the prohibition on interracial marriage?
Well, I think it's horrible that you would even conflate those two cases and the intent behind them. They were, obviously 60 years ago, there were laws that were with a discriminatory intent to basically treat the races differently. That was the intent. This is a case in which the local governments, the state governments, are intending to protect children from possible irreversible and harmful effects. So these are completely two different things, two different points of view. It was a conflation that I could barely follow. It did not make sense to me.
Yeah, it's rather bizarre.